Hi, everyone. Thank you for joining today's webinar presentation, How Classification Works at the USPTO and the Implications for Software Patents and Computer-Related Innovations. My name is Allie Morton. I'm the Product Marketing Manager at LexisNexis IP, and I would like to just cover a few things before we get started. This webinar is a follow-up to a webinar that we held back on May 14th, and today we will take a deeper dive into the specifics around software and computer-related innovations. You will be able to access this webinar, the previous webinar, in the email that we send to everybody as a follow-up. During the webinar, please feel free to submit questions using the questions feature in the control panel. And also in the control panel, you will see a handout section. This is where you can access files pertaining to today's webinar, including the webinar slides. A follow-up email of the recording from today's presentation will be sent out later today. Also, we have a lot of great information to cover in today's webinar, so we may go a little long on time. If you're not able to stay, that's okay, don't worry. You can listen to the full recording later when we send it out via email. Now, I would like to introduce today's presenters. With us, we have Megan McLaughlin, the Product Director for LexisNexis Patent Advisor. After graduating from Harvard Law School, she worked as patent attorney at the law firm of Nutter, McLennan & Fish. Her technical focus reached into a variety of industries, including medical devices, the food industry, software, printers, and biotech. Also joining us today are Tanya Habuer, the Knowledge and Training Manager at Serco IP. She's responsible for building the patent classification training program at Serco IP. Tanya has presented at numerous industry events, including PIUG, IPLA, and brings over 14 years of patent experience to our panel. We also have Jeffrey Sullivan. He's the product manager for Serco IP Patent Search. He has an extensive background with a degree in computer information systems and an MBA with an innovation focus. His technical background includes telecommunications, graphics and displays, and video and image processing. And last but certainly not least, we have Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean has been named one of the world's leading IP strategists by IAM Magazine. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Thank you, Allie, and thank you all for being with us, and thank you, panel, for joining me here today. I am really excited about this webinar. You know, I should probably say that with such vim and vigor about all of my webinars, but, you know, when LexisNexis, just let me gush for a minute if I can. LexisNexis has been a partner of mine for a long time, and they let me largely pick the topics, which is great. So I get to talk about things that I find really, really interesting. And I find this topic extremely interesting. Now, as Allie mentioned, we did a version of this, generally speaking, about classification and how the USPTO decides where applications get routed and how and why and to which art units, and what you can do when you're drafting an application to affect that process. We had so many questions from you in the audience during that webinar that we talked and we decided that why don't we do one that focuses specifically on computers and software specifically. And then I looked at, and it was news to me during that webinar, we'll talk more about this during this webinar, that the old USPC plays a role in determining which art unit gets which application. So I looked at the old USPC, which I hadn't done in a while, and I noticed that computer implemented invention or computer implemented method is not even defined. And computers defined in two different areas, go into two different groups of art units. And I thought, oh my God, this is going to make a great topic. LexisNexis agreed, and we brought the people back from Serco who actually do this for the USPTO, and this webinar was born. I also, before we get going, if we can move to the next slide, I'm happy to let you know that this is going to be part 2 of what is now a 3-part series, because I've confirmed that the Commissioner for Patents at the USPTO, Drew Hirschfeld, is going to join us on July 30th, and we're going to get free CLE to give away. So tell all your folks at your firms that if they need a free credit of CLE, and who won't take a free CLE credit, we're going to give away free CLE credit on July 30th. We're looking at getting CLE for all 47 states that require CLE credit. And we're going to talk about this topic, classification, and particularly routing applications to examiners and how examiners handle applications. And Drew is going to be joined by some folks on his staff that are working on this initiative particularly. He's going to talk to us. We don't have a title yet because we've only just confirmed this date, so save the date. It's going to be a great conversation. Those of you who joined us last year when Drew joined us in June know that it was a wonderful conversation. So looking forward to that again. Now, I've taken more time during my intro than I wanted to. We're going to skip the general thoughts and ideas because we have a lot of slides, which is why Ali said that we may go long with taking as many of your questions as you have. So if you have questions, please send us your questions. In likelihood, we're going to save them to the end so that we can get through as many of these examples that Serco has put together as possible. Now, with that, Tanya, I'd like to kick it over to you so that you can start the presentation. Now, during this going back and forth, Megan and I may ask you a question here or there, if you don't mind, but please take it away.
No, absolutely. Questions are great. Well, everyone, as Jean mentioned, the USPTO uses classification to assign art units. And so today we're going to be exploring how that process works. And to frame our discussion, it's important to understand that classification is designed to be a system for categorizing the subject matter of inventions, and that the US classification system is comprised of broad categories that are called classes, which are then subdivided in what are called subclasses. And each classification symbol is a combination of a class and a subclass, like the example on the screen, class 118, subclass 724. Now, on this next slide, you can see that the USPTO has mapped each of the 150,000 plus subclasses to an art unit. And as new applications are being filed and classified, they're assigned exactly one what's called primary or original classification. And you can think of that primary classification as a routing classification. Because each available US classification is mapped to an art unit, whichever art unit a given primary class and subclass is mapped to is where the application is routed for examination. So if we want to understand the art unit, we're going to need to understand how our primary classification's assigned. And there are two rule sets that work hand in hand for this. There are broad rules defined in the USPTO's Handbook of Classification. These are applied to every patent document regardless of technology, but there is also a body of art-specific rules. The art-specific rules are spelled out within a set of definitions that exist for each class and subclass, and they serve to clarify what art belongs here versus there in the classification system. And if you take those two together, these two sets of rules provide a very robust framework and inconsistency in the primary classifications that are assigned to patent documents. Now, in terms of the broad rules of classification, the process for selecting a primary can be summarized by 4 steps. With step number 1 being that the claims of the application are reviewed in the context of the entire disclosure. 2, claims are classified to at least the class level of the classification system. Here's where that second set of art-specific rules fits into the process. Step 3 is a tiebreaker process in case you've got claims within the claim set that are directed to multiple classes. And then finally, step 4 provides a tiebreaker when there are multiple subclasses in the primary class. So today we're going to be focusing more on the art-specific rules, the ones that are found in class and subclass definitions. And if you're interested in exploring these art-specific rules, these are also published on the USPTO website. The link that you see on the slide is going to take you to a list of classes and their titles. And by clicking on the Go buttons that you see, you'll be able to view either the schedule or the definitions for the class, whichever you select up above. And on the right, you see an example of the definition for class 705. So here on this next slide, you're looking at a bird's eye view of both the class 705 definition and the 705 schedule. That's clearly a ton of information. So how does one go about making sense of all of this? if you look on the left side of the screen, you see a suggested sequence of where to look to make sense of all of this information. So I'm going to turn things over to Jeff, who will walk us through each of these areas using Class 705 business methods as an example.
Thanks, Tanya.
And by
So
the
when
way,
you first
if I
look
can
at a
interrupt here,
Yep.
sorry, if I can interrupt here for just a second so that people, so the listeners know, Class 705 generally corresponds to some of the most difficult art units at the U.S. Patent Office in the 3600s. So that's the concept. And then Class 706 corresponds to some art units in the 2100s, which are generally have higher allowance rates, more lenient examiners, less Alice rejections.
Yeah, and just to let people
wanted people
know,
to have that context.
yeah, where we're going with this, 705 is typically, by and large, the business method art unit. And what we're going to get to here is just a quick preview so you know where we're headed, is a view of how you could draft things so that you would head towards 705 in really the pit of despair, and how you would redraft that same thing and you would head towards a 706 classification and head towards an art unit that would be you'd be virtually guaranteed to get a patent. So take it away, Jeff.
Yes. So when you're first looking at a class schedule or a class definition, taking a look at the class schedule itself is actually a good idea. So basically, a class schedule is hierarchically arranged with all the subclasses that make up that particular class. So in essence, you're really getting a list of examples of the types of art that can be found in that class. Within classification, the way we like to train new classifiers is we use a phrase, scheme defined scope, which is basically a reminder that everything that's classified in a class is going to be classified into one of these particular subclasses. So the schedule is first providing an indication as to the scope of the class. But keep in mind the subclass titles are not necessarily the final word. We really need to take a look at the definitions of those subclasses to help really understand and frame the scope of that particular class. So if we go to the next slide, let's move over to the class definition. So every class has a beginning of a definition statement, and there's several sentences or paragraphs of the class definition that basically clarifies what type of subject matter is provided for in these particular classes. So in the case of 705, we all know, as Gene said, this is the business methods area. So if you take a look at the language in the definition, and on the screen there, we've provided the definition for 705, and it lays out this generic class for apparatus and corresponding methods for performing data processing operations. And then we've underlined some of the key words there that actually pop up quite a bit within the class itself. So you can see there that it generally provides a framework for business types of applications. So the reason that those data processing language is actually very important here is that 705 is a part of a 700 series of classes that really relate to all digital data processing. So that language is indicating where 705 fits in the series of that data processing array. So 705 is for the application of data processing to a business environment. Scanning through the language in the definition, we have data processing operations that's utilized or designed for administration of an enterprise or business. Also, data processing includes charge for goods or services. And so when we're reading an application and classifying it, we're really looking at what is the problem being solved. And if the problem being solved is really some form of a business operation and there's some form of data processing involved, we're really talking about 705. If we go to the next slide, we're looking past the definition. The next point that you should really look at is to look at scope. Usually classes will have some type of scope defining limitation. So when an invention appears to fit the subject matter of a class, it's a good idea to look at any clarifying notes. So within 705, there are 5 notes, which are listed here on this slide. If you go to the next slide. So Further down in every class definition, there's also references to other classes. What this tells you is that there are usually overlapping classes or subject matter that may cross lines with particular art. And so this kind of gives you a bird's eye view into what you may see that goes there. So for example, you see class 283 listed. The title of 283 is printed matter. And you see a scope clarification that business forms are classified in class 283 rather than 705. Keep in mind, every class has a list like this. It's not an exhaustive list, but it gives you it's a good first place to look when you're trying to evaluate if your particular invention may be categorized in one class over another. So if you go to the next slide, usually in classes, there is a glossary. Now, each glossary is specific to each US class. And so in there may be terminology that is defined within that particular class. And keep in mind, between the classes, terminology may be defined a little bit differently. Here's just some of examples of what's contained in the 705 glossary. And so it may be actually a little bit different than maybe the industry terms that you may be used to seeing. And so that's where classification and reading these definitions and reading these scope limitations really comes into play. So really what we're talking about is, now that we have a general understanding of class 705, let's compare it to class 706. As we mentioned earlier, 705 really is that place for classifying business types of inventions. Since AI technology is used, it's frequently used in business applications, getting a side-by-side look of these two classes really helps us provide context and helps us understand when inventions overlap the space and what would be classified in class 705 versus 706. So if we go to the next slide, we can see the 706 definition here. And so 706 is another class within the data processing series. Here it's specific to artificial intelligence. And here you can see that it's the general place for artificial intelligence where computer data processing occurs. But specifically, it's really meant for the details, methods, products for emulations of intelligence, knowledge-based systems, knowledge acquisition, AI, fuzzy logic, adaptive learning, machine learning, and neural networks. And if we go to the next slide, we can see between, as I mentioned earlier about the scopes, when you're comparing 705 business method area to 706 artificial intelligence, there's really two notes that come into play here. And really in 705, you have note 3, and that's a very, very important note for 705. And basically it's saying that, significantly claimed apparatus or process to this class that's claimed in combination with the subject matter that fits 705 are classified in the class appropriate to the external device or art unless it's explicitly excluded. So really 705 takes significant claim recitation of data processing. So one phrase you may have heard before is that the claim is the name of the game. And definitely within 705, that is very true. So your claim language needs to be technically specific. Also in class 706, we see that there's a note there that says this class can accept combinations of data processing arts with artificial intelligence not elsewhere provided for. So essentially, we've got a framework now to where we can see, 706 is really the data processing area where functional and technical detail is really geared towards the algorithms or the makeup of how the AI is going to function, how the adaptive learning is set up. And 705 is really meant for more of just the business methods themselves without a whole lot of external detail. So
Jeff, I think we may have lost you.
Yep. Did we?
There,
Okay.
there, yeah. Yeah, that's okay. Actually, Jeff, I wanted to interrupt you for a minute because I think this is so crucial what you just said. So and tell me if my interpretation is wrong, but what I'm hearing you say, and what this note, the scope clarification seem to say is, you wouldn't end up in class 705, business methods, the 3600s, even if you recite a business method, so long as you also recite a bunch of other stuff. So you can recite a business method and not end up there.
Absolutely. So just a mere mention, a lot of things are done with a computer that, everything's a business process nowadays. So really what the essence of this note is really telling you is that if the only thing that you have is just a broad business method, or, you're doing some type of business function, and really you're doing it with a computer, if you don't provide technical details to the computerized process that you're really claiming, what's really inventive, then it's more likely you're going to be directed to a 705 area versus a 706 area, or maybe another classification.
Okay.
So, but
I want to.
Go ahead, Megan.
Go ahead, Gene.
No.
I just want to clarify one other thing that you said, Jeff, which is with 705, the claim is the name of the game. Is that not
correct?
So with 705 in particular, the focus is on the claims. Got it. Okay.
Correct. It's claims. It is claims, but it's also, we do read claims in light of that disclosure, as Tanya mentioned earlier.
Okay.
So really the claims provide us insight into kind of what the inventive nature is, and we can pull that information. It can be included in the specifications. It may be a description of a drawing. There may be some type of algorithm or business process that's laid out in the specifications that goes into detail, maybe about one subcomponent of the invention. Maybe it's a particular module or something.
So, Jeff, the question that I had is when and I've been thinking about this a lot since I saw the slide deck, is with the note 4 for 706. It seems as if you only get into 706 if you haven't been captured by one of the other sections, one of the other classes. So you've got to navigate almost like the gauntlet to get into 706. Is that correct? I mean, because it seems like the way I'm reading note 4 is it says you can't get into 706 if you can be accepted into one of the other classifications.
Correct. And really what that comes down to is that in the 700 series of classes, there's different, requirements for each of these. And so, yes, you would follow that sequence. And depending, if you got to 706, that would mean you have eliminated all the other possibilities. And you would put it there as long as it wasn't provided for elsewhere. So even, for instance, in 382, which is image processing, there's a whole learning area within 382 image analysis. And so this note's really telling you that really if there's a place somewhere else, it really should be placed somewhere else. So in that case, documents that are talking about image processing where learning's involved, really that would be classified outside of 706.
Okay. Yeah. So that's interesting to know. So 706 is sort of like it hasn't gone somewhere else, so it's got to go somewhere. So it goes there.
Yeah, and you have to meet the main requirements of the class too. So there has to be.
Obviously. Yeah.
Right.
I mean, so yeah, I didn't mean to like belittle that in that sort of way. But and I guess what I'm thinking about there is that then mean, because let me tell you where I'm coming from. It seems to me that if you get a 706 classification, as we're going to see here in a little bit, that your odds of getting a patent go way up. And that may be partly self-selecting, right? I mean, because the applications that get filed are probably much better and they're probably much more substantive if they don't fit somewhere else. Is it that they are really cutting edge and the office doesn't have another place for them and they're forward thinking, forward leaning, and new technology type applications? Or am I reading too much into note 4?
Yeah, I think maybe that might be a little bit of a stretch. I think really what really guides, for at least in our processing, really what guides our decision making is really these notes. And so when we're viewing an application in front of us, we're really making the decision: is the problem being solved really rooted in artificial intelligence per se, or is it really a business process? Now, these two can be hand in hand, but really, what is the claim disclosure describing? And so, if the application does not include details of artificial intelligence or really dives into artificial intelligence, we will generally steer away from 706.
Okay, so one last follow-up there. So you're not necessarily talking about like the point of novelty as much as the technical disclosure or detail, correct?
Correct.
Okay, so you're looking for, to get into 706, what we, at least I have always described as a thick technical disclosure that actually shows you have an innovation in technology in play.
Sure. Yes, we look at what the technical advantage is, what the inventor says they've invented, and then we apply these series of rules to that disclosure.
Okay, great, awesome.
Just one follow-up, Jeff. That mention of not elsewhere provided for, that's a pretty common phrase in class definitions. And so it's not that this is only something that you would see in Class 706. Is that a fair statement, Jeff?
Absolutely.
Yeah.
And there's within the U.S. classification system, there's generic classes, there's residual classes, that's even a little bit more confusing, but residual is even one step beyond a general class. So that really is the leftovers of the leftover areas. And so it's common to see this kind of language in those arts as well.
Okay. All right. That's all I have. Megan, did you have anything else on this slide? I mean, because this slide really caught my attention when I was looking at this.
Yeah, no, I think you covered most of my questions on here too.
Okay. Well, if we go to the next slide, what we have done is really laid out kind of what are some of the broader concepts that this technology usually brings up, and these terminology, computer implemented method, computer readable storage media system. How are these concepts actually handled by the U.S. classification system? And on the next slide, what we have done is really provided you a very general definition statement based on all the 700 classes. And so really what we've defined as a computer here is really a machine that inputs, processes, stores, and outputs data. That's a pretty general statement, but when you look at it's important to go back, with any definition that you find for any of this terminology, is really, once you're looking at a class, as I mentioned earlier, each class may have a glossary and may define things a little bit differently. Computer implemented method is simply a systematic operation on data that is in accordance with some type of rule set that results in a change in data. So you got data that's coming in, you're doing something with it. Maybe the process or the meat of the invention is really what you're doing with the data. And then there's an output somewhere. Computer storage media is really just a representation of data in a coded manner that the computer can be interpreted electronically through the computer. It could be transmitted, something like that. The term system, and we see this quite a bit, it's not just in computer art, but system in relation to computer art and data processing is really just an assemblage of components either at a single location or has several components that's spaced geographically. So you can kind of think of it as you have a standalone system versus a network of systems. A system can be defined as a device. It can be a collection of devices. It can be a collection of modules that communicate with each other. So that really helps provide context to, this art in general. And I will turn things back over to Tanya.
All right, thanks, Jeff. Next, we wanted to try to apply some of the concepts that we've talked about so far to an example application. And we briefly mentioned this example last time, but today we're going to give it a different context. On the right, if you recall, these are our 4 broad step rule sets for primary classification that we talked about earlier, where we said that step 2 is the entry point to these art-specific definitions that we also talked about. And the example we're going to use involves a neural network for categorizing and forecasting. So we're going to apply each of these 4 classification steps to our neural network example. So starting with step 1, the classifier is asked to review the application as a whole to understand the invention. The claims are what's being classified, but it's the claims read in light of the entire disclosure, as Jeff mentioned. So here you see the bullets representing some of the classifier's observations at the end of step 1. They've noticed that there are 2 groupings of claims. You've got one group of claims that's to a neural network that uses a classification engine to evaluate and categorize user product reviews and nothing more. And you've got a second group of claims that does that and also further comprises a forecasting engine to predict market changes based on those review categorizations. So that's one set of observations that's important coming out of step 1. And I haven't mentioned observations related to the disclosure, but we'll come back to that in a little bit. So with step 1 complete, next we're going to turn to step 2. And step 2 is directing the classifier to classify each claim to at least the class level. And in order to do that, we're going to need to consult those art-specific definitions that Jeff talked about earlier. And just as a reminder, these can be found on the USPTO website. For this invention, there are 2 potentially relevant classes, Class 706 and Class 705. And if we were not familiar with these classes, just as Jeff described earlier, we could look at the class schedules, and we would find that there are subclasses in each of these classes related to the concepts found in these claims. So you would find neural networks in 706. We would find subclass for product reviews in 705. But here for step 2, we need to examine the definitions of these classes much more carefully, because each claim is only permitted to be classified in one class, with some rare exceptions, but just one class for each claim. So we're going to need to choose between 705 and 706 which one is more appropriate for each of our claims. And the definitions are how we're going to be able to do that. So if you recall the evaluation sequence that Jeff stepped through earlier, it started with those initial statements in the definition about the intended subject matter of the class. And when we're comparing a claim to those statements, as we are here, the classifier should be looking beyond the surface language of the claims and also drawing upon their understanding of the disclosed invention. So classification is categorizing inventions. So during step 1, if the classifier found that only a business problem was being solved and there was no indication that the neural network may itself be novel, then 706 should be ruled out. There would be nothing further to look at right now. We would be finished. But for 706 to remain in play, the neural network aspect would need to be potentially inventive. And we don't have the entire disclosure for this application in front of us, but can we imagine both of those possibilities? One possibility could be a disclosure in which existing neural network technology is simply being applied to the business problem of evaluating reviewers and forecasting market changes. If that's the case, it seems like the neural network aspect doesn't have anything inventive about it. And if that were to be what we would find in the disclosure, then 706 would be ruled out. If we don't have inventive 706 subject matter, that is. On the other hand, another possible disclosure for these claims could say something like there's a need for a neural network capable of predicting market changes based on user product reviews. And here's what we're doing with the neural network. We're doing X, Y, and Z to enable it to solve this business need. That would be a situation where we have a disclosure that indicates there could be something inventive about the neural network subject matter itself. So if we've got both business method and AI aspects look like they could be part of the invention, then we're continuing to look at 706 and 705, and we would be continuing to work our way down through both of those class definitions until we find something definitive as to which class is more appropriate for the claims that we have. So for this example,
Tanya,
yes.
Can I interrupt you here for a minute?
Yep.
So I think I know the answer, but I just want to be super clear. When you're trying to understand whether a particular aspect of the claims is novel, are you relying entirely on what the applicant themselves are saying, or is there ever a situation where the classifier might make their own determination about whether something in the claims is novel?
We're only basing that on what the inventor is saying. There is no searching going on here. And I don't know, Jeff, if there's anything that you want to comment on in addition to that.
Yeah, I think that's accurate. Really, what we're tasked with is looking to see what the inventor has stated that they've invented, and then we're digging into those elements to see, does it meet the requirements of the particular candidate classes that are available, and then going through that process.
Okay. All right. So entirely based on how the inventor frames it.
Yes.
Okay. I figured. I just wanted to clarify.
Yeah. Yep.
All right.
So in this example, we're going to assume the second scenario I described, where we have some indication in the disclosure that both the neural network aspect as well as the business method are part of the invention. So now that we've found support for both classes, and we're looking further down through the class definitions for something that's going to differentiate these two classes, now is the point when we're going to find these two scope notes that you see on the right and that Jeff talked about earlier. There are many notes in both of these class definitions, but these two are relevant to this example because they're addressing how combinations of subject matter are handled by these two classes. The 705 note, in essence, says that nominally claimed subject matter of an external class, like 706, results in classification within 705, but significantly claimed subject matter of an external class, like 706, involves classification outside of 705. The 706 note is complementary in saying 706 can accept combination subject matter. So if we apply this nominally claimed versus significantly claimed criteria to our example, and if the wording, on the screen is representative of the actual language of the claim, then the outcome would be that the level of artificial intelligence detail in our claims is not rising to the level of significantly claimed 706 subject matter. So classification would be deemed more appropriate in 705. So that probably raises the question of, okay, well, what would the wording need to be to count as significant? In our current claim, that bare mention of a classification engine would need to be expanded into greater detail. So for example, something like the language shown in the hypothetical second claim. Here we have a detail that's describing the neural network. And with that added detail in the second claim, now we have both the appropriate disclosure as well as the significantly claimed artificial intelligence details, which are what's necessary to meet the classification requirements for 706 rather than 705. So that hypothetical claim with that adjustment to adding those technical details of the neural network, that would be classified in 706, but our actual claim, it doesn't have those technical details about artificial intelligence, so it's going to be classified in 705 instead. So we went off in a bit of a hypothetical tangent. Now we're coming back to our actual example. As we look at both actual groups of claims, neither of them is including significantly claimed detail to a neural network. And so both groups of claims are going to be classified in class 705. That means we've established a correct class for all of our claims, which means we've completed step 2. Moving on to step 3. Step 3 is a tiebreaker for situations when claims are drawn to different classes, but that's not the case here. All of our claims have ended up being classified in 705, so we don't need a tiebreaker, which now takes us to step 4. And step 4 is a tiebreaker when there are 2 or more subclasses within the primary class. And as you can see, we do have 2 subclasses listed next to our 2 groups of claims, 347 for the first group and 731 for the second group. So, let's use step 4 to talk about subclasses. And we're going to start with our second group of claims, which further comprise making market predictions based on review categorization. And it says here that these would be classified in subclass 7.31 of class 705. So we're going to take a look at the Class 705 schedule, and the title of 7.31 sounds like a pretty good fit for that second group of claims, market prediction or demand forecasting. Now that good fit is not always the case. Sometimes the subclass just seems like an odd choice. Maybe there's another much better sounding subclass somewhere else in the class. And a lot of times people wonder, why does that happen? There's a perfectly good looking subclass, but it got classified somewhere else. There are a couple of reasons why that happens. And one of the reasons is that the method by which subclasses in a class schedule are chosen, it's not best fit, but rather first fit. So the idea is that you start at the top of the schedule and you work your way down to the first appropriate place. So that's one of the reasons that you can look like you have a disconnect. Another reason that a relevant sounding subclass might not have been chosen has to do with the hierarchical relationships of subclasses to one another. And if you can see in the screenshot, most of the subclasses have one or more dots in front of them, and those dots are representing indent levels in parent-child relationships. So if you click on a subclass title, you'll see the pop-up window there on the screen, and what that's doing is it's displaying the subclass you clicked on, as well as all of that subclass's parent and grandparent subclasses. And really that entire lineage is kind of like the complete subclass title. So, in the case of 7.31, I should be thinking about 7.31 as a subclass for, and I'm just kind of paraphrasing here, a business method, class 705, with automated financial, business, or management arrangements involving operations research or analysis, involving market data gathering, analysis, or modeling, which provides market predictions or demand forecasting. That's kind of like the full title of 7.31. And so those relationships to parent and grandparent subclasses can be another reason why sometimes an obvious appearing subclass is not the one that's chosen. Now, subclasses also have definitions. If we click the Show Definition View button, we can see the definition for subclass 7.31, which further defines the intended subject matter of the subclass. And the subclass definitions can also include references to other classification places. These are subclass references are usually additional to the references that Jeff showed you at the class level. So the definitions can be very important as well. Now here, this next slide is really not part of the classification process, really just kind of an aside. Class schedules also provide links to example patents. The letter P that arrow is pointing to is a link to patents that have 7.31 as a primary classification. Again, it's not used in the classification process, but it may be something that helps to provide insight into different subclasses that you might be looking at in a class schedule.
And this matters too, right, Tanya? Because we've been talking a lot about, the difference between 705 and 706. 705 goes to a lot of the more difficult art units in the 3600s, and the 706 goes to some of the easier ones in the 2100s. But there are significant differences even within the 3600s, right? And down at the subclass level, the different subclasses will take you to different art units, right, Tanya?
Definitely. That's especially important in class 705 because, yes, I don't know if you remember, Jeff, but I want to say there's something like 5 or even more different art units within class 705, and each of them, has a little bit of a different lottery map and allowance rate and other kinds of factors. So yes, exactly where you end up in class 705 is also pretty important.
Yeah, that's accurate. It's like 5 art units.
Okay, thanks. Okay, so next we'll just take a quick look at the second subclass, subclass 347. Once again, the title appears to fit our first group of claims reasonably well. If we click on the title, we can see the hierarchical context of the subclass and also its corresponding definitions. And if you notice the definitions view, starts with the first subclass in that hierarchy, 1.1, and you can see a scroll bar over on the right. And that's because definitions and scope limitations of a parent subclass are also inherited by child subclasses. So just as we saw with the title, all of the parent definitions need to be considered when selecting a subclass as well. Okay, so now that we've taken a closer look at our two subclass, we're going to return to step 4 of that 4-step primary process because we need to break the tie between these two 705 subclasses and determine which one is going to be the primary subclass. The guidance in step 4 says to locate each subclass in the class schedule, and whichever is highest, that's the one that's going to be the primary. And here we see that 7.31 is higher in the schedule than 347. And so 7.31 is a subclass that's going to be our primary classification. And so here at this point, we've completed all 4 steps, and we've arrived at a single primary class and subclass 705, subclass 7.31. And earlier today we described the primary classification as a routing classification because classification is the means by which the USPTO determines the ART unit. So if we want to just kind of close the loop on that here, and we want to know, okay, we've ended up with a primary classification, what is the ART unit where this example would be examined? What we would do is simply consult the USPTO's mapping information on their website, and that mapping information would tell us that ART unit 3623 is the ART unit that's mapped to classification 705, 7.31, and so that's where this example would be examined.
So Tanya, can I stop you here for 1 second?
Yeah.
So I think this is probably going to be an obvious question, but I'm going to maybe lead you along here. But so when you're doing this classification, you're classifying based on the claims, correct?
The claims are what is classified, and those claims are interpreted in light of the disclosure.
Right. Okay. So now, if you claim less than what has been disclosed in the application, that affects the classification, and it would affect the ART unit, correct? So
yes.
The thing that Megan and I, when we have this conversation, okay, so I'm a nerd, and I think Megan, is probably a nerd too, at least at heart. But
I'll own it.
yeah. So we have this conversation a lot, and it's, are you better off when you're filing quote unquote software patents, whatever that means to whoever you are, not to file method claims? Now, I've said yes for a very long time, simply because I think that the courts interpret method claims in a very negative way, and it sours the whole pot. We saw that at the Supreme Court level, and we see it consistently from many of the panels at the Federal Circuit. They interpret your method claim and they say, oh, and we really know all you're trying to do with your system claims is claim the same thing you were doing with your method, so that's patent ineligible too. So that's been my rationale. But looking at this, what I think is that you would, and then also looking at what we did the last time with methods being higher on your determinative classification analysis, routing, that you'd be better off not claiming the method at all, and then having your routing to the ART unit based on the systems claims. Am I crazy?
I'll let Jeff speak to the business methods and the computer implemented software, but in classification in general, it's very art specific whether method, apparatus, product makes any difference at all to how or where something is classified.
Yeah,
so it really will depend.
So before we turn it to Jeff, Megan, did I really capture?
Yeah.
I feel like I maybe didn't capture the essence of what our last conversation was, because I know you looked at this US piece, the classification system, a little bit closer.
Yes, I read the classification handbook, which, if anybody ever needs to go to sleep at night, is a really great resource. But what I was focused on was this step number 3 on your slide, Tanya, where the primary class depends not so much on the subject matter of the claim, but on what kind of claim it is. So, first you look at which is the most comprehensive claim, and then that'll be the primary class. But the second thing you look at is what the category of subject matter, and I didn't understand the reasoning for the prioritization at all. But what I found out was that the prioritization had something. It was something like, the first priority is process of using, then the second priority is a product of manufacture, and so on down the line. So if you have a claim towards the process of using, that one's the most likely to be the primary classification. So if you've got kind of a scary software claim that is phrased as a process of using, then it does seem like it would be more likely to take you into a classification where you might not want to go. So that's why I was thinking it also might make sense, to the extent that you have a claim like this, not to write it as a method claim.
And then that being the case is, and not knowing exactly, because then I started thinking, when Megan told me that, I'm like, oh my God, with software, method of using versus method of making doesn't really track exactly the way that it would naturally with an apparatus. And I'm like, so just out of abundance of caution, for a variety of reasons, just don't do it. But I mean, I'm really interested in your guys' answer.
Well, I will comment about the 705 subject matter. I would say the methods by themselves, like if you define, if your end goal is to provide a software application that's not going to end up in business methods, then you really need to focus if you're going to write a method claim, really focus on the tech itself. So if you can write and really point out in the claim language the very specific processing that you're doing, and make it abundantly clear that it's more than just a computer that's executing steps. If there's a particular module and that module has several parts to it, which can be defined and explained in more detail, then that's generally gonna give you better results, I think. So in terms of classification, the methods and apparatus, they can be classified, and many times are classified in the exact same place. And so really understanding what the definitions are saying in those classes really help provide that. So from a classifications perspective, I don't think it means as much, perhaps, in terms of you're talking about what's going to be allowed or potentially gone through. And so with classification, really don't get into that level of detail.
Okay, so really it boils down to, well, actually, in some level, maybe it does. I mean, this is probably maybe this is part 4 of this series, because I bet you, if we sat and looked at the patent method claim, the method claims that were ineligible, they would be ones that lack the tech largely that we're talking about here, and probably would be routed to bad places. And the ones that are eligible are the ones that do have the thicker tech, and would be routed to places that are better. And maybe that explains the difference in allowance rates. Maybe it's that simple. I don't know, but we would obviously need to do some kind of analysis on that. So let's just move past that for now. But I think, Megan, that may be something we need to take a look at.
Yeah, I think there is something there.
Yeah. All right. Tanya, sorry I took us off on that sidetrack, but.
Oh no, that's a very relevant sidetrack. All right, and we're really going to just wrap up here with a couple of conclusions, and just kind of start out by kind of reminding ourselves that art units are not equally desirable, and that's really why classification is of interest, and we're looking at this topic today. The art unit your application ends up in can suggest whether you're going down an easy road, up ahead, or if you've got a difficult road up ahead of you. And that further insight is, what's so helpful about, things like the LexisNexis lottery maps, and, just the wealth of information about art units that you can find in pathways. And what classification does is it helps you to predict the art unit and to sense those potential paths ahead before you file. So Next, we're going to wrap up with just a few observations about classification in general. Many features of an application can impact the art unit. We saw the disclosed context of the claims is important in terms of the claims themselves, the scope of the claim set as a whole, as well as specific language within each claim can affect classification. And another thing that we saw is that classification uses two distinct rule sets that provide a very specific and clear roadmap to follow. And we focused on the art-specific rule set in class definitions today, but also how those fit into the broad rules of the primary selection process. In terms of business methods, usually primary classification is in class 705 when a solution to a business problem is what's presented in the claim disclosure. And usually classification is outside 705 when a more nominal business process or improvement is combined with another significantly claimed and disclosed improvement. There can be exceptions, gray areas, but that's typically the difference. And then in terms of considerations for drafting in light of today's discussion, in the specification, what problems are being solved? If your invention really is just a business method, expect that that's likely how it's going to be classified and that it will be examined in one of those 3,600 art units associated with 705. If your invention is other than or more than a business method, make sure that you're communicating that clearly when you're drafting, not only in the disclosure, but also in the claims, because the details that you include or omit can make the difference for how your invention is perceived and classified and ultimately where it's examined.
And
so I'll go ahead and turn these over to Megan.
Yeah, go ahead, Megan. I know you have a hard stop. There was just something that popped in my head, but I know you want to talk about this. And this is really important, I think.
Yeah, so if any of you listening to this call, gotten to the end of this and you're thinking, wow, this process is really complex, and I'm not sure I've gotten my head around it, because I don't think I have either. LexisNexis has actually partnered up with the experts at Serco to help you out. So if you have an application, you're trying to figure out which art unit it's likely to be assigned to, particularly if it's a software application and it matters to you. What we'll do is we'll actually get that application in front of one of the classification experts at Serco, and they'll give you an opinion on where that application is likely to go, along with some statistics from LexisNexis about whether that's a good thing for you or a bad thing for you. And also, as a promotion, if you're on this webinar, we're going to be offering these reports at a significantly discounted price for you. So if you're interested, please reach out to Morgan Connell. Her address will be on one of the upcoming slides.
So is that the last slide here, the last substantive slide that we have, or the last slide that we have?
Yes, it is.
Yeah. Yep.
Okay. So the question that I had and Megan, I know you've got a hard stop at 1 o'clock, and thank you for participating. So please feel free to just leave us if you need to, when you need to. And those of you who want to stay on the call, please feel free to stay on the call. There's a bunch of questions I want to get to here, and one of the questions that came to my mind that I was just so anxious to get out, that kind of captures a handful of the questions that have come in throughout the hour, is a question that also came up during the last time we did this, is about filing continuation or CIP, and then having that classified in a different art unit, that sort of thing. And I was going to put, if you could address that, that'd be great. But I was going to put maybe a little twist on that, because I have always encouraged the students I teach in all these webinars that I do, and all the presentations I give and the writing that I do, that the best way to prosecute is, to the extent that you possibly can, is to, at least in 2020, at least in the modern era of prosecution, is to file at least one claim, hopefully more than one claim, but at least one claim that you think is allowable at the time that you're filing it. And maybe looking at all of this information, maybe the idea ought to be, in the first application that you file, you're filing a narrow subset, very directed subset of claims that you have a really good feeling that they're allowable and are really going to be directed towards something substantive and technical. Because I believe I recall that you said that when you classify follow-on applications, children, grandchildren, you look at the classification of the previous application. So if that's correct, then getting that first application classified becomes very important. Now, there's a lot there, and I don't know whether Tanya or Jeff, maybe both of you comment, or whoever is best suited to comment. If you could address that, that'd be great.
Well, I'll answer that, and Jeff, if you want to add on, but yeah, applications are classified, early in the process, and so yes, that very first initial filing is going to get classified, fairly quickly, and it's going to make its way then to an art unit. And while the USPTO certainly may ask us to classify a continuation or divisional or a later filing, that is not as likely to be the case. So that initial filing, certainly is going to be that first mark of kind of getting that patent family to an examiner. And Jeff, I don't know if you have any additional comments on that.
No, I think you captured everything correctly there, Tanya.
Okay. All right. So now I got a question here, and I know that this is something that a lot of people have told me that they feel happens, and I don't know what. So I remember in the first webinar that we did, we talked about that you guys do the classification, and the PTO is responsible ultimately for which art unit it goes in. So sometimes they will make changes for a variety of different reasons, including I know in some of the 705 units that sometimes they didn't have a whole lot of cases, so they were pulling stuff into those art units. But there seems to be some attorneys out there that feel that there is a discrimination based on assignee, and not only in the examination phase based on examiners, but they think that, and they feel that there's a discrimination based on classification in that when you represent somebody that is a tech company, such as, for example, Apple, the invention is viewed as a technological invention, whereas if you represent somebody, like, I'm just going to pick Wells Fargo, for example, they may be doing the very same or similar type of thing in the e-wallets area, for example, with a lot of thick technical details, but the bank is much more likely to have it go to 705, where the tech company is more likely to have it go to 706. And I'm wondering if you have any thoughts on that. Is it just happenstance? Is it, or is there something in the tiebreakers that would push it that way?
There isn't anything in the classification process that has the classifier looking at that kind of information. So that's really, I think, kind of outside the scope of of what Jeff and I are probably able to comment on.
Mm-hmm. Okay. So let me see if I can pick off some more questions.
Go to the question, Tanya, can I have you go to slide 39, please? We have some questions coming in about how people can access the discounted pricing for the pre-filing classification reports, and I just want to make sure everybody knows where to go. So actually the next slide then, please. Yep, that one.
Yep,
and
thanks.
We'll be sending out a survey when you close out of the webinar today. You will receive a survey right there on your screen, and one of the questions is if you would like to purchase the pre-filing classification report at the discounted $299 off of the list price of $495. So if you would, you can just click yes there, and we will reach out to you as well, or you can reach out to Morgan directly here with this contact information.
So yeah, this is something that I think if you have an important application, I think that that's something that you probably ought to think about doing, because this is it is a very important. I mean, once these things get classified in a certain area and an examiner gets assigned, it becomes very difficult to take that away from that examiner with follow-up continuations and part continuations. They tend to go back to that same place. So that first filing is so critically important. I mean, there's some ways that you can provoke it, and I do happen to know, like with track 1, the same examiner doesn't always get assigned because they rotate within the art unit the track 1 application, so no examiner gets overburdened based on how fast the timelines are. But these first applications are so critically important. Now, we have a quick one, I think, here. Beyond 706, what are the classes that are common alternatives to 705? Jeff, I think maybe that one might be for you.
Well, I mean, for sure, any of the 700 classes, because you're dealing with data processing. So, perhaps modeling in 703, class USPC 703 that takes simulations and forecasting and computerized analysis. 708 is also another one that comes to mind, which is more of the arithmetic processing behind the code. How computations are arrived to. It really 705 is such a big area. It really can touch many areas, counting machines, registers, that type of art. But in the data processing art, I would say any of the 700 series of classes. Control systems in 700 would be another one, but it can be pretty expansive.
Yeah. So we have a question about magic words in the area of artificial intelligence to either use or to avoid. And Megan, are you still with us?
She is no longer. She signed off.
Okay, she did sign off. So I do know that with Pathways, LexisNexis has a tool, Pathways, that they can do an automated analysis, and they will target certain art units, and they come up with what they call a keep list and a kill list, like use more of these words, i.e. keep, and stay away from these words that you're using, i.e. kill these from your application. But there's probably a much more sophisticated answer to that. Tanya, Jeff. Tanya, do you have anything?
I wonder, Jeff, if you'd want to answer this one.
Yeah, I would say, it's not necessary. I don't have a series of words that are definitely good.
Yeah.
I would say going back to those class definitions from a classification perspective, looking at the glossary of terminology there, and then looking to see how that language is categorized in those definitions is probably the best answer I can give you.
Yeah. Go ahead, Tanya. Go ahead.
And maybe also, Jeff, you were talking earlier about making sure that you're including the technical details in the claims if you think that is representative of your invention.
Yes, that's accurate.
Yeah, so the definitions wind up being the best thing. And we have some questions here about why the Patent Office continues to use the old USPC, and that's not a question for Serco. We'll try and get those questions maybe addressed by the commissioner when he joins us in July. It is what it is. That's what they use, and it's important for you all to know that that's what they use, and you can find that online at the Patent Office website. So we have a question, and we answered this during the webinar, but early on, I think, and then the example at the end only used one classification, and it is just one classification that is applied. I'm sorry, one USPC that is used to determine classification, correct? It's not multiple USPCs.
The primary classification is always a single classification. In the old days, when the USPC was used for searching as well as for routing, then applications would receive multiple classifications. That would be common, that were more search classifications rather than routing classifications. But today, it's correct that you end up with just one primary classification. Along your way towards that primary classification, you kind of saw in that neural network example where different claims in an application individually could be classified in different classifications. Different symbols might apply, but that four-step process is, a process of narrowing that down to one. We always have to have one at the end of the process for one primary classification.
Yeah. So another good question here. If you believe the application has been misclassified, what do you do, or is there anything that you can do?
Jeff, do you know the answer to that one?
I'm actually not sure.
I know that the USPTO talks about liking examiners liking to have interviews with applicants, and if you are doing kind of that research yourself into what you believe the appropriate classification is, my guess would be that would be something that USPTO examiners would welcome, having that conversation.
Yeah, I'm 99% sure there is a way to do it, and I'm not sure how to do it. What I would do is I would just recommend, if first line always is ask the examiner. If the examiner is not helpful or forthcoming or doesn't know, maybe call the ombudsman and see if there's a way, because this would deal with procedure, not substance, I would think. And so maybe that's something the ombudsman can help you with, or at least they'll tell you one way or another if there is some way. What I would also do before I did anything is I would look through the NPEP just to make sure that it's not easy to find, because I remember, I have some memory that there is a way to do it, but I can't recall the particulars. We have a question here. Where does the USPC appear on the U.S. patent application cover sheet? It's not on the cover sheet. Where can I find it? I was just looking on Public Pair, and I think I saw it on Public Pair. Do you guys know, or?
The USPTO used to publish the US classifications on the front page, but now they have discontinued that because the US classification system is no longer being used for search. They only list, 1/1 is the US classification that they list for all new patent applications. So that is something that they have discontinued publishing.
Mm-hmm.
To my knowledge, there may be a place in PAIR. I don't believe I've looked in PAIR recently, but I'm not aware of a place where they are publishing that for new filings.
Yeah, I'll see. Let's see if I can pick off a quick question, and then yeah, actually, Chris is saying yes, PAIR. It is now in PAIR.
Okay.
So yeah, and that's what I thought. I was just looking at PAIR yesterday, and for another purpose, and I noticed it in PAIR. So if you go and check PAIR, it is listed there.
That's good to know.
Yeah. Okay, so if there are, this is a good question. If there are some claims in the 706 and there are some claims in 705, how do you determine classification?
Okay, yeah. If we have some claims in each class, then we would be using that step 3, which is the primary class test, kind of that tiebreaker process is what would be used in step 3. And basically, Megan was also talking about this, where step 3 is giving you a sequence of steps or tests that you apply to the claims. And the first thing that you do is you look at all of the claims and you say, is one of these claims more comprehensive than the rest? And if the answer is yes, then the class associated with the most comprehensive claims, that would be what's called the controlling class. If there is no most comprehensive, then you go to the next test, which is category of subject matter. And do I have method of making? Do I have product? Do I have apparatus? And there would be an order of superiority there. And so on down through the list, but there's a series of tests that are listed there with step 3 that would be how the classifier would determine which class would be selected when you've got two classes represented by the claims.
Okay, and just going back to the other question about changing art units, Chris pointed out here, and I know Chris is a patent attorney that I know pretty well, and he reminded me you can petition the director for anything. So you could petition the director for a change. So if there's not some other way that the MPP has a process to do it, you could always just use a general petition and ask for a change in the classification. So you can always ask, and that's what's great about those the general petition is there's no other specific petition out there, but you want some kind of relief. So you just file a petition with the Office of Petitions. So let's see if we can pick off maybe one more and then we'll call it an afternoon. Is classification always run by a human classifier, or is it automated partially or fully, or does it depend, or what are the factors?
Yes, all applications are classified by a person. So it's a very complex set of decisions, and so it really takes a human being who understands the rules, all of the nuances of the definitions, to really be able to apply all of the different criteria that may be relevant to each given application. So certainly there's artificial intelligence out there that can be interesting and helpful, and that we use for various purposes. But at the end of the day, it really is taking a human being to know what the correct classification is that needs to be assigned to any patent application.
Yeah. These decisions are difficult, and so if anybody is interested in taking up LexisNexis and Serco on this, I'd invite you to do it and give it a try and see, because like I said, once these applications get attached to an art unit or an examiner, it is, experienced patent attorneys know, it is virtually impossible to shake them loose. And that is the most common question that I get from everybody, both new practitioners and old practitioners who are hoping that there's become a new way to do it, is how do I get this application removed from an examiner? And there's simply no satisfying answer for that. So you really need to take this very seriously on the front end and do what you can. And you can affect where these things go with, I wouldn't say creative drafting, it's thoughtful drafting and drafting with a purpose, and making sure you focus on the technology and have these thick, gone are the days, completely gone are the days that you can file anything computer implemented, i.e. software, with a cheap, thin disclosure. And if that's what you're gonna do, just tell your client to save their money, because it's just not, save their money until they invent something that's worthwhile enough for them to spend on it, so that you can really file something that matters. That's my final thought, but I'd like to get your final thought, Tanya. And Jeff, what one thing do you want people to leave today remembering? Tanya.
I guess that classification provides a lot of insight into how examiners think, and where your application is headed. And so there's a wealth of information available that's out there if you'd like to learn more about how classification works.
Yeah, thanks, Tanya. And Jeff, your final thoughts today.
Yeah, I would say paying attention to the details you include or omit in your claim language is very, very important, because it does play a factor in the analysis of where documents get classified. So kind of to your point earlier about disclosure, if you can provide kind of a thick detailed disclosure that goes along with your claim language, and you can define that claim language in a way that provides clarity, that's going to be the best thing for you.
Okay, well, thank you guys. I really appreciate you taking the time and spending an extra 20 minutes here with us today to answer these questions and taking all my questions. And I appreciate the audience sticking with us as well. And I hope you all can join us at the end of July for the free CLE with Commissioner Drew Hirschfeld. And we have another webinar scheduled for next Thursday. So hopefully you'll be able to join us for that one as well as our webinar series continues. Thank you to LexisNexis IP. I hope you have a good rest of the day and a good weekend, and we will see you all soon. Thanks for attending.